education can be, and I hope so, a good influence for a common European legal system. And I know that there are lots of lawyers in Europe, they are working very hard on that. And yeah, thank you very much for your attention.
Thank you, Bettina. Thank you very much. And we take a flight now all the way 10 hours down to Kampala, Uganda. And there we meet Anthony Kabuza, the Dean of Uganda Christian University. Anthony, you have 7 minutes.
Thank you very much, Professor Franceschi. Ladies and gentlemen, good afternoon. I'm also quite excited, privileged, honored, everything, to be here presenting before you my experiences teaching law in Uganda, as well as what I have to share about harmonization. And I'd like to start out by again adding my voice in appreciation to International Association of Law Schools, Barbara, Professor Francis, and the team for everything you've done for us, as well as especially a special note to Symbiosis Law School. Back in Uganda, when we talk about what identifies Ugandans, we always talk about hospitality, that Ugandans are very hospitable, but I've seen more hospitality here from Symbiosis, and we thank you so much for the way you've been treating us. So I'd like to get on down to our experiences, and when I say our, I'm speaking about Ugandan legal practitioners, and then cutting it down to my personal experiences as a legal educator for the past close to 15 years in terms of developing curricula and what we look out for in harmonization. And I start by the question of understanding how do we get and keep students interested when we're teaching students. It goes back to what Professor Sullivan was talking about, motivation. How do we motivate them and keep them motivated? And in order to motivate the students, in order to keep them interested in what they're learning, not just in 1 year, but throughout the years that they're in law school, we need to understand these students and who they are. And in our experience in Uganda, the majority of students who study law, and by law I mean undergraduate law, are students in the group of what we call millennials, that is those in the late teens to the early 20s. And millennials are different from the different age groups. We start by looking at who are the traditionalists, for instance. These are those who were born between 1910 to the mid-30s. Then you have the baby boomers who were born between the mid-30s to the mid-60s. Then you have the Generation Xers who were born between the late 60s to the late 80s. They have different interests. Then of course the millennials, born between late 80s to late 90s. And currently the dot-commers, those beyond. Now with millennials, there's one thing that defines them or characterizes them. These are people who like working in teams, at least the majority. And then there are those who love engaging or interacting through social media. And then of course those who enjoy using all sorts of IT gadgets and entertainment. So if this is something that identifies them or something that they all love together, then those can be avenues that we use when we are engaged in legal education. So the idea of teaching them the way they can relate to matters quite a lot in order to attract that motivation and keep it. And with that as a foundation, we look at the experiences I have had in legal education in Uganda. And one of these is we use a lot of law and the movies. Bring out a story through how it can be portrayed through a true story. I teach intellectual property law, and I used to teach real property law. And through all this, one of the ways that we engage with the students was to show a true life story. Particularly, say in my intellectual property classes, we share with the students movies such as The Social Network or The Founders, or movies such as Joy. All these are stories based on real life events that bring out the real intellectual property story. And as students relate from what they're seeing, they don't only understand the course units, but can connect the dots as to the origins, the understanding of intellectual property enforcement, and the like. Then we also have community engagements, either solely as Uganda Christian University or in partnership with non-governmental organizations. We bring in our students who have studied particular course units, say land law, for instance, and connect them to non-governmental organizations that are out there advocating for land rights. So they use our students to go and disseminate information within local communities on such matters, and through this partnership, not only the non-government organizations, but also legal practitioners that also teach in the law school will take up cases for those people who need to have their matters addressed through courts. So you're stretching the accents, the element of community engagement with legal aid clinics or bringing clinical programs. And this is something that not only Uganda Christian University, but Cavendish University, which the dean is present here, as well as Makerere University's Principle of Law, will all do together or in harmony in trying to ensure that our students are appreciating not just the theoretical side of the law that they've seen in the classroom, but they're taking it now down into the communities and seeing the practical side of that. The other thing is merging the Socratic discussion of cases and study materials with personal practical experiences. It helps for us to have staff members who are also legal practitioners sharing the cases that they have in court with the classes that they teach. So it helps for us to have not only legal practitioners, but also court magistrates come in as part-time or adjunct professors. We also integrate moods and debates in our classrooms or in the curriculums. Now the challenges from all this is, one, when we talk about a harmonized course curriculum, and I'm happy that Professor Kalantri brought out a good definition of that, it's not necessarily A to Z of the same curriculum, but picking out the minimum standards. And from what I've been seeing with the various emails sent by IALS, one challenge is that many of the professors have a difficulty in allocating time to sitting down and agreeing together and having a common curriculum. So pick out what really works for your institution. It's related to what Professor Wang was saying. We want a bottom-up approach and not a top-down approach. Use the standards that apply and relate them to your particular situation. Secondly, integrate that with an agreed-upon standard from your group, your study group, what your institution can work with. Yesterday I was sharing with Professor Sullivan, and she said that we need to look at how you can compare policies or legal situations in different countries. And in making that comparison, you're getting to understand the bits and pieces from the different institutions and jurisdictions. And then after that, we agree on a common teaching style that is quite effective, with common inputs, activities, and outputs. And lastly, encourage collaborations with or through the IALS as a platform. We have a collaboration with Strathmore Law School in Kenya, but one thing that has guided us is what can we both do that relates well for our students. And when we agree on what relates for our students, we end up having a common curriculum. So thank you very much.
Thank you, Anthony, and thank you all the speakers for keeping time so faithfully. We are catching up somehow. And now we don't take a plane to Zimbabwe, we take a bus. It's possible to go from Uganda to Zimbabwe by bus. Emmanuel, the floor is yours. You want to speak from here or from the podium? Exactly, okay. Of course. We know you are not small.
Not at all.
Excellent. So the floor is yours.
Good afternoon, colleagues. Yes, if I were sitting on the bench, I would have simply said, I concur with everything that has been said by earlier speakers. But anyway, on a more serious note, I must start by putting on or placing on record my own personal sense of appreciation, profound appreciation in that for the hospitality, amazing the hospitality that we have been accorded here. But special mention really ought to go to the students. They are a wonderful bunch of human beings, very courteous. I was going to say very courteous, very helpful, and very, very pleasant. Keep it up. Right. In terms of harmonization, what are the minimum bodies of knowledge that are essential across the board universally? I would say that regardless of where one is coming from, regardless of their jurisdiction, there are certain principles which are in common currency, particularly in the field of contracts, which is our baby as a study group. issues like principles of agreement, freedom of contract, factors which vitiate the validity of a contract, things like fraud, things like misrepresentation, things like illegality. Then the question of breach of contract. What constitutes breach? I'm sure in every jurisdiction, in one way or another, one has to grapple with that issue. And of course, the all-important question of remedies. Can we harmonize our curriculum? Can we standardize? And what are the underpinning notions? Of course, the notion of justice, the notion of fairness, the notion of rule of law. But it is important to take these notions or to regard them in a particular context. The social context in our world, or in my part of the world, is very important. The cultural and social milieu. Talking about social context, what we have done at my university in the teaching of law is to use the legal aid clinic as a vehicle or a platform or a practical way of teaching students. We divide our students into teams or firms. The clinic gives them an opportunity to break away from the traditional ivory tower, as it were. At the same time, we are able to use it as a platform or as a vehicle to contribute to social justice. The question of access to justice in my part of the world is very topical. In fact, by conservative estimates, about 70% of our population is unrepresented. The litigants are self-actors. The major themes or topics that our students grapple with in the legal aid clinic are things like, oh, okay, sorry. You didn't miss much. Things like contractual disputes, family law issues, maintenance, divorce, alimony, chieftainship wrangles, succession disputes. As I said earlier, this is our own humble and modest way of contributing to the access to justice narrative. I was only given 5 minutes by Louis, and Louis sometimes can be very strict. To summarize, the question is, can we have a curriculum which respects the diversity of contexts and approaches? Yes, in my humble opinion, it is possible to do that. It is possible to universalize or to internationalize the curriculum. There are certain minimum bodies of knowledge which every student of contract, no matter where they are from, no matter their jurisdiction, has to appreciate or must have an appreciation of. Such skills, for example, are as follows. Skills related to the alternative dispute resolution, skills relating to drafting of contracts, skills relating to interpretation of contracts, skills relating to contract negotiations, skills relating to client counseling, skills relating to globalization. Contracts are increasingly becoming transnational and international in character. So the question of transnational corporations, how they interface or relate with host institutions, host legal institutions is very, very important. The law governing acquisitions and mergers is equally important. It's possible to harmonize all those issues. After all, we are now a part and parcel of the global village. No country is an island unto itself. But a word of caution in all this, it is absolutely important, it is absolutely imperative for us to take the social context on board. It is absolutely imperative for us to harmonize whilst cognizant of local conditions, local peculiarities, and local sensitivities. I thank you all.
Thank you, Professor Manuel, and this has been an amazing punctuality. Now, in this interesting panel, which started half an hour late, so that's why we are a bit behind schedule, but don't panic, we are catching up. We had Sital, who spoke to us about harmonization, and she did that through technology, which is a very interesting aspect that has been popping up again and again in this forum. Bettina brought into context harmonization and diversity, because they are living together with the European Union, but they are not married. Then Switzerland, that is. Then Anthony spoke of millennials. He brought up a very interesting aspect we have been neglecting for 2 days here, not speaking about millennials and how they engage and how we can find some minimum standards. However, when he mentioned minimum standards, a word Frank Wang has been repeating again and again is commonalities, and perhaps it's the better term because doesn't bring in the idea of minimum, keeping low down there, which is not what Anthony meant, certainly, but that's a very interesting point. And then Manuel, knowledge across the board, teamwork, break the ivory tower, and how to get those skills that are universal